Hello and welcome to our webinar today on ISDA initial margin documentation, focusing on custodian risk and the relationship with the account control agreement. This is part of a series of webinars that ISDA is providing on recently published documents to allow parties to comply with their initial margin regulatory requirements. My name is Mark New. I'm Senior Counsel at the Americas at ISDA, and I'm here today to introduce our speakers. We have Douglas Donahue, who's a partner at Linklaters, and Blair Graver-Rains, who's a Vice President and Associate General Counsel at Oppenheimer Funds. Doug, over to you.
Thank you, Mark. So we will take a look at slide 2. And slide 2 is really an overview of where we'll start today. But even before we do that, we should probably give you a sense of what the entire presentation will cover. So today what we'll try to do at a high level, because all of these items in and of themselves can be complex, and some of them will actually be covered in future webinars. What we will attempt to do is give you an introduction of the concept of independent custodians and really focus on how that will affect the negotiations that you'll have in the Reg IM space. We will talk about custodian risk allocation. We will identify when parties can actually access collateral held by their independent custodians, what the consequences may be of one of the two trading counterparties breaching any of their agreements under the CSA or the relevant custodial documentation. And finally, we'll touch on the relationship between the account control agreements and the ISDA collateral documentation. And I should say, you'll hear us use some of the terms that are very common under the New York law documentation, like pledgor and secured party. You've already heard me say a number of times CSA, and you'll hear me say account control agreement. Those terms are really just being used for ease. The concept behind all of those terms is really what we're trying to get across. So just to give you a quick example of what I mean, when I say CSA, what I'm really talking about is the New York law CSA, the English law CSD, or the jointly published collateral transfer annexes, or CTAs, and security agreements that ISDA has published. So some of the things that we need to keep in mind when thinking about custodians and independent custodians is really a key decision at the beginning of a preparation process for regulatory initial margin, even before you think about negotiations, is who will my custodian be? And the reason that decision is so important is because that will then drive a lot of other decisions that you'll need to make, both from a documentation perspective as well as from an internal operational perspective. Once you know who your custodian is, a key question will be, well, for each of my trading relationships, who is my counterparty's custodian? And again, that will drive documentation choices as well as operational choices, this time rather than at your firm in general, really at a trading relationship level. And then finally, I would say, while we can all say who the custodian is, you'll also want to know what sort of custodial platform you are using, as well as your counterparty. And the two platforms that are out there are tri-party and third party. And just a quick note as to what each of those parties, what each of those platforms do. Under a tri-party platform, the custodian takes a much more active role. They'll value collateral, they'll move collateral on an automated basis. Under a third party platform, it's much more manual for each of the parties. They need to direct the custodian to do things. Things don't happen on an automated basis. What many of you may be familiar with are actually third-party custodial platforms, because that has been sort of the norm in the derivatives world for segregation prior to Reg IM. Once we've moved into phases 1 through 3 of the Reg IM space, we have seen really the market standard become tri-party platforms, because again, a lot more of what's going on in the background is automated.
So looking at this slide, first of all, thanks, Doug, and thanks, Mark. You'll see the relationship sort of in a relatively, well, for some of you, it'll be actually fairly common and simplistic form. For those of you who are used to posting collateral on a bilateral basis, this may look a little bit intimidating. So let's just go through what this diagram shows. It shows in each case you have the trading relationship, party A and party B, that are going to be exchanging initial margin pursuant to the terms of the credit support annex. As Doug said before, this doesn't have to be a CSA, but for ease, we're going to just refer to it as the CSA. And this relationship will allow for back and forth of pledging regulatory initial margin. Now, the pledge is done under the CSA, but the account, there's going to now no longer just be, you're not going to be pledging directly to a counterparty where the counterparty is perfecting by holding the collateral. Now you have an account with a third-party custodian that's independent of the party that you're trading with. And the security that you grant under the CSA is going to be perfected under an account control agreement. Now, as mentioned just a little while ago, for some of you, that's going to be fairly common. The buy side has been segregating independent amounts for some time using what are now known as third-party account control agreement setups. And so this may be familiar for some of you. Under this diagram, as you can see, there's a custodial agreement related to the segregated account for the custodian up at the top for Party A. And Party A is going to have to be posting IM and collateral is coming out of the custody account, which is unpledged, and it's being moved to the segregated account, which is pledged at its bank custodian. Now, I would point out here, now this may be the same custodian, or it may not be. You may try to institute a special custodian sort of solely for the purposes of posting IM, or it may be the same custodian that you have been using for some time. That will in part depend on your relationship with your dealer. It'll in part depend on your relationship with your custodian, and it may depend on your commercial choices. As you move, as the Party A IM amount goes into the segregated account, the security interest that has been pledged under the CSA is being perfected in favor of Party B, and you can see that up at the top. At the same time, and this is what's new about this Reg IM space, is that Party B also is a pledgor under these documents, and it has a similar relationship going down along the bottom. Now, there may be two account control agreements. There may be one account control agreement. That will depend in part on the documentation you're able to agree with your custodian. Right now, the market has been creating two separate documents for each of the pledgors. That doesn't have to be the case. Now, again, you'll see the same basic relationship. What the documents you'll see in that we're going to describe allow for a great deal of flexibility between the parties. So you could have different custodians, you can have different account control agreements, and you can have different custody relationships, all within the same trading relationship.
Thanks, Blair. So as we look at example 2, we wanted to show a variation of the illustration that Blair just went through. And while all of the concepts are generally the same, there are some important differences on the illustration you have in front of you. And where I would focus everyone's attention is really right down the middle of the illustration. So as you will have noticed on the slide that Blair previously went through, there was a single IM credit support annex, and that was because we had two bank custodians who were both located in New York. In this example, we still have one bank custodian who is located in New York, but the custodian for Party B is actually Euroclear or Clearstream in the example. And what that means and how that affects the documentation, getting back to one of the high-level points for Reg IM negotiations that we wanted to touch on today, which is how the choice of custodian will impact the documentation that needs to be put in place. You'll see that the parties now cannot rely on just putting in place a single IM credit support annex, but they will be required to put in place the IM collateral transfer agreement as well as a security agreement. Now that's required because the IM CSA or the IM CSD published by ISDA do not work with either of the Euroclear or Clearstream platforms. Instead, ISDA and Euroclear and Clearstream separately co-published documentation in the form of the CTA and security agreements that are specifically tailored to work with those platforms. In addition to that, I would just note that rather than having an account control agreement, as you do between the three parties for purposes of the bank custodian at the top of the illustration, where we have Euroclear and Clearstream, the three parties are really signing up to the membership documents. And that's an important distinction because that negotiation actually doesn't happen for every single trading relationship. Those membership documents are really agreed once. You're not looking at a new set of membership documents for each trading relationship. So that's an important distinction as between Euroclear or Clearstream as custodian and having a bank custodian under New York law in this context.
So moving on to the next slide, the allocation of custodial risk in relationship with the account control agreement. One of the important considerations that everyone faces when you have this third-party custodian in the relationship is who bears risks associated with the custodian performing or not performing or withdrawing or being removed. And the documentation, as consistent with documentations that's been on the market sort of for independent amounts up until now, deals with those risks and allows for the counterparties to the CSA to allocate risk as they see fit. So who will bear the risk of the default? What happens if a custodian defaults or withdraws or is removed? What happens if the counterparty says that they won't touch your collateral, but asks for the collateral anyway from the custodian? The relationship between the control agreement and the CSA or the other IM documents, what governs if there's an inconsistency? Who has to make the calls about what the value is? All of these options are available within the new IM CSA.
So one obvious question then becomes, well, who bears the risk of the IM custodian either defaulting or resigning? And it has become market standard that the pledger chooses their custodian and as a result is the one bearing that risk. Now, there is no regulatory requirement that the pledger choose the custodian. That's just how phases 1 through 3 have developed and how I would expect at least it can to continue to develop, because the pledger needs to create a relationship with their custodian that they then branch out to all of their trading relationships. So in general, the way that the documents are set up is that they put the risk of a custodian failure or resignation and what that may mean on the pledger. And there is a general statement in the ISDA documentation that the pledger will be liable for acts and omissions of the custodian, unless the custodian event is applicable. And the custodian event was a way for people in the market to really agree exactly what would happen if a custodian defaults or if a custodian resigns. If custodian event is not applicable, then we would just have the statement in the ISDA documentation that says that the pledger will be liable for the acts and omissions of the custodian. But we would not have kind of an agreed upon process to, one, terminate the trades and to understand what the exact remedies are and damages. So looking at the right hand of this screen, we have, we've quickly gone through what would constitute a custodian event. As you will see, other than number 3 in that definition, all of those are some sort of default or breach by the custodian. Number 3 is actually a custodian resignation, and that's interesting because that's not a breach or a default by the custodian. Instead, it's a voluntary act by the custodian, and thus far what we've seen is all of the Reg IM custodial documentation will give the custodians the option to resign with X number of days notice. And so the market needed to address that. And the way they've addressed that is that they've made that part of the custodian event provision. And now really the question then becomes, at least for me, what are the consequences of custodian event? So you're the pledger, you don't want to be liable for all acts and omissions of the custodian without knowing exactly what that means. So you and the secured party have agreed to make custodian event applicable. A custodian event now occurs. Well, what is it? What is that? What's the consequences of that? Well, first and foremost, it's important to know that it's not an event of default. In fact, it's a mid-market ATE with one, and there is an exception for the delivery of a timely statement. But in general, it's a mid-market ATE in respect of all covered transactions. And that's important because it does not terminate or does not provide either party the right to terminate all transactions in the entire portfolio between the two parties. Instead, it only allows the parties to terminate covered transactions, or transactions that are in scope of Reg IM, which makes a lot of sense, at least to me, because really the event, or the event that's causing the ATE is only in respect of those transactions, and as a result, the consequences should only be in respect of those transactions. Now, you may be asking yourself, well, okay, now that I know what the pledger's obligations and what the results of obligations are with respect to the custodian, and what the results of a custodian default or resignation have in general, how about the secured party? Well, from the secured party's perspective, their only obligation with respect to the custodian is to provide appropriate instructions so that the custodian can move collateral. They don't take any risk that the custodian will fail to actually act on the instructions. Their obligations are satisfied as soon as they give appropriate instructions.
So moving along, on the next slide, we see the basic provisions, or a basic illustration related to collateral access, showing a party as pledgor. Now, as you can see here, there's a segregated account that's held by an independent custodian, and delivery amounts, IM, and return amounts, IM, are going back and forth from the pledgor to the segregated account. Now, how exactly the return amounts come back, whether it's just an instruction of the secured party or joint instructions, that'll be something to pursuant to commercial negotiations that's decided between the parties. That's the everyday back and forth. Now, in the event that something bad is happening, you have in the IM CSA the so-called secured party rights event, and then you have pledgor rights event. Now, what that's intended to do is allow either the secured party, in the case of bad events occurring, or in which you're going to be closing out the pledgor and taking the IM, to access the collateral. The pledgor, simultaneously, to the extent, again, there's issues with the secured party, may want to pull its collateral back that it's posted, in which case it will exercise its pledgor rights event. We're going to talk about each of those concepts more in a second, but the idea is basically the same as what's occurring right now under third-party account control agreements right now. You have access conditions in which the secured party can foreclose, and you have access conditions in which the pledgor can gain access back to its initial margin. This is both on a bilateral basis, that both parties can be pledgor or secured party at the same time, and will be.
Moving to the next slide, which is the collateral access provision slide. So what I will say is this is really a sneak preview. There is an entire webinar that is going to drill into secured party and pledgor's rights and remedies that will go into this in a lot more detail. But given that we've been talking about the custodians and their documentation and the relationship between that and the ISDA documentation, we thought it was necessary to at least give people kind of a sense of what the collateral access provisions say and when they're activated. So I'll do that in really short order and really point people to the webinar that will talk about this in much more detail. So from the secured party as well as the pledgor's perspective, access to, or I should step back a little, in the 2016 documents, the only thing you had are really the top two boxes there, the notice of exclusive control and the secured party rights event, as well as the pledgor rights event definitions. And those definitions were hardwired in the documentation. Those definitions continue to be hardwired in the 2018 and 19 documentation, but there's an option actually to turn them off and replace them with previously agreed concepts that get at the same point. But let me explain a bit. So under both secured party access rights and pledgor access rights, an event of an early termination date in respect of all transactions must occur before either the secured party or the pledgor, as applicable, can access any of the collateral that's segregated in either of the two segregated accounts. That's the base rule. That is what's hardwired into the 2016 documents as well as the 2018 and 19 documents. But on the basis of feedback that we received during the consultation and drafting process for the next generation of the 2018 and 19 ISDA documents, people said, well, you know what? I have negotiated very similar concepts in the past into my control agreements, and I would like to preserve those agreements as opposed to using the forms of these access provisions that are hardwired into the documentation. So what was added to the next generation documentation was really what I would call a switch, and that switch allows parties to replace the hardwired secured party access rights and pledger access right provisions with those that they've previously agreed in their control agreements. And now this obviously is only going to be applicable if you have actually previously agreed these types of provisions. But if you have and you would like to retain them, and we received a lot of feedback that there is some appetite for that, you now have a very user-friendly way to incorporate those provisions into your CSA, CSD, or CTA, whatever the case may be, so that you get the benefit of your previous negotiations. One thing I would also highlight is that these elections are really collateral direction specific or collateral flow specific. And what I mean by that is a party as pledger and the other party as secured party can agree to flip one of these switches. But when each of those parties are in the other role, they don't have to flip the switch. And that's important because in most cases in the past, only one of the two parties, not in all cases, but in most cases, one of the two parties would have a segregated account, so would have agreed these or potentially have agreed these types of provisions. So we are not forcing people to kind of apply the provisions to both sides of the relationship, but instead you really have maximum flexibility and can customize to follow what you've agreed in the past.
One of the other key concerns is, again, sort of to the extent that you have these agreements in here where the secured party will not access your initial margin, which, as we know, is sort of generally over-collateralization. You're concerned about that over-collateralization being taken when it's not supposed to, and both parties should be because they're both secured parties. So the question is, how do you prevent that from occurring? Well, there are covenants that you will not deliver a notice of exclusive control until one of these events occurs. There's similar things on the pledger side, and there will also be covenants in the account control agreement, most likely, that says you will not deliver instructions or entitlement orders, assuming that this is a U.S. document, absent an event of default occurring or a specified condition. You'd like it so that that earlier condition, if someone gives an instruction that they're not supposed to, causes a breach under the credit support document, the CSA or CSD. And there's different ways to accomplish this. One, you can make the control agreement a credit support document, wherein a breach of the control agreement leads to credit support event of default. As it's noted on this slide, you can have it so that it's a breach for one but not the other. Similarly, there's a new concept here in the IMCSA, which is called a collateral access breach. The collateral access breach indicates that if you do not, if you violate a covenant and you seize the collateral, create instructions when you're not supposed to, that it leads to an ATE. Here, a collateral access breach, and all transactions will be affected transactions. The idea being, again, if you're delivering as a secured party a wrongful instruction to deliver collateral to you, the other party can try to close you out. They don't want to deal with you anymore. The new collateral access breach provision in the IMCSA does allow for a cure period. Parties are expected to probably make that quite short, if there's any at all, but that will be a commercial negotiation. The relationship between the control agreement and the IM documents. Now, you might ask, what happens if I have different provisions in my control agreement than I have in the CSA, again, as to when I can access things or I can't access things, or how value is going to be created or not value is going to be created, is going to be measured. And the IMCSA allows for flexibility on that as well. Again, to the extent you have legacy documents or you have a document which says that the custodian is going to calculate the value, as would be the case in the tri-party account control agreements, you can state that where the control agreement is inconsistent with the CSA, the control agreement prevails. Or you could have it the other way, where the CSA prevails. And that's an election that the parties can make, and they can make it with respect to each party as the posting party, or they can not make it, as the case may be. Similarly, there's a provision that allows for the control agreement to be, again, the dominant thing, to the extent the CSA would calculate value one way or require each party to be calculating value and exposure. The custodian itself, under the tri-party custodial platforms, will be doing this on a regular basis. And the idea would be that the custodian itself is moving collateral back and forth between the unpledged long box account to the pledged account and back and forth, as the case may be. And therefore, the custodian calculations rule, again, that really works on a tri-party account control agreement basis, not so much for the third party. And you can have different elections, just like each party can have, one can have a third party account control agreement, the other can have a tri-party. You can have different elections on this point. Now, my personal opinion is that it's going to get pretty hairy if each party has different elections. It may be difficult in practice to make that work, but the document allows flexibility so that parties can make their own commercial judgments on the point.
Thank you, Blair. That brings us to the end of the presentation for today. I'd like to thank both Blair and Doug very much for today's presentations. If you have any further questions regarding this webinar or any of ISDA's initial margin documentation, please do contact us at ISDALegal@ISDA.org. That brings us to the end of today's webinar. Thanks very much for listening.